Good afternoon, everyone. And I would like to welcome everyone who's attending our webinar on impunity in Turkey. We are very glad that we have a high number of people who registered and already more than 300 people who are now present. And we had around 1,000 people who showed interest. And most probably, or for sure, it has to do with the importance of the theme of impunity that we will discuss today. We have, for the moment, around nearly 400 people. Everyone, of course, can give us questions, and we will try to answer them. Of course, with a high number of people who are attending, it will not be possible to respond them all. Some I will immediately respond also, otherwise I will give the floor to our speakers. And we will start immediately today with the first of our 6 speakers, and that is Emre Turkut. Emre is a PhD in law, specifically around the measures that came after the coup and under the system of derogation of human rights. And he wrote a report for the Turkish tribunal. The Turkey Tribunal is an initiative that we took, and the tribunal will be held beginning of May. Emre had this report, I just show it, Impunity in Turkey, and he will explain now in 10 minutes the general lines of the report that was made on impunity in Turkey. It has been published in September 2020, and you can find it in extenso on the website of turkeytribunal.com.
Thanks for the opportunity, Johan. I would like to thank everyone who is here with us today for attending great numbers, and hope this webinar raises an awareness in fighting the impunity in Turkey. And at the outset, let me say a couple of things with regard to how we define impunity and what sort of a problem we're talking about here today. So what is impunity? In the context of international law, we define impunity as the failure or the impossibility to bring perpetrators of human rights violations to justice and account. These human rights violations are usually some of the grave violations of international protected rights, such as torture, enforced disappearances, and extrajudicial killings. And when we say perpetrators in an impunity context, the focus is on state officials, usually law enforcement agencies such as police forces and military members. And besides constituting a denial of many human rights, particularly victims' rights to justice, impunity also violates many of states' obligations under international law, because it is a direct threat to the rule of law and human rights, which states have to both respect and promote under international law. Now, impunity is a long-standing problem in Turkey, but it has unfortunately been one of the most common themes of Turkey's human rights rollback in the last decade. And we can mention tens of striking examples, such as the Roboski massacre in 2012, where over 30 civilians, Kurdish civilians, were killed by airstrikes launched by the Turkish army. And this was indeed one of the gravest crimes in the history of Turkey, but the incident was not properly investigated by Turkish state authorities at all. And another striking example that I can mention is the Gezi Park, anti-government Gezi Park protest from 2012, where there was a widespread police violence, but 8 years after the protest, there is still a near total impunity for their actions. And in more recent years, especially in the aftermath of the 2016 attempted coup, we also see that the practice of impunity, as well as the allegations of torture, widespread systematic torture, have dramatically increased. Which is why we put the particular focus of our report on the post-coup period. Now, in the report as a whole, we ask ourselves two important questions. Is there an effective system of preventing and monitoring torture and mistreatment for people held in detention? If yes, how does it function in reality? And if not, can we speak of an organized impunity in Turkey? Now, to quickly jump to the inevitable conclusion of the report, we find that there is not an effective preventive or sanctioning mechanism towards acts of torture and ill treatment. So the findings of our report, which I will start sharing in more detail now, clearly speak of an organized, institutionalized impunity problem in Turkey. Now, how does the impunity function in Turkey's domestic fora? And in the report, together with Prof. Ak from Ghent University, we comprehensively identify a number of systematic and structural factors that ensure and in fact reinforce the patterns of impunity in Turkey. And one such factor is gaps in the Turkish legal structure or insufficient, or you can say insufficient legal safeguards. There are many impunity clauses under Turkish law currently, which make practically the prosecution of state officials impossible. For example, members of Turkish police cannot be prosecuted without the explicit permission of relevant administrative authorities. And we see that in the vast majority of cases, such permission is not granted. Well, just to give one example, and as most of you would remember, Hrant Dink, who was a Turkish Armenian journalist, and he was also a human rights defender. He was murdered 14 years ago in 2007, and in his case, there were clear indications that the police, the Turkish police, and the gendarmerie officers of Trabzon and Istanbul had been involved in his murder through at least negligence. And this has been indeed corroborated by many investigation reports of the Turkish Ministry of Internal Affairs, as well as by the finding of European Court of Human Rights, in his case in 2010. However, the formal investigations into these officers, or maybe I can say into masterminds of his murder, have been considerably delayed because administrative authorizations were not granted for such long time. I mean, his trial is still ongoing in Turkey, but due to many shortcomings during the trial stage, 14 years on, impunity still lingers, unfortunately, still lingers in his case. And another factor is the lack of political will to hold state officials accountable. And this is also visible in many post-coup cases. For example, in the report, one of the 3 case studies we took a closer look at is the torture of purged diplomats in Ankara in 2019. And a report by the Ankara Bar Association, as well as many other reports by different human rights organizations, provided clear and convincing evidence of torture of these individuals, including stripping people naked, beatings, and threats of being raped with batons. But despite official complaints lodged, Turkish authorities did not take any step at all to fully investigate these incidents. And the Ankara Chief Public Prosecutor's Office issued a non-prosecution decision into these complaints in August 2020. And the third factor, maybe more like a subcategory, is the political rhetoric downplaying the scope of the impunity problem in Turkey. And this is, of course, nothing new in Turkey, but in the post-coup period, the tone of the political rhetoric got really harsh. And in the post-coup period, almost every single international and intergovernmental organization in their reports, including the United Nations Special Rapporteur on Torture, the United Nations and the Council of Europe Commissioners for Human Rights, and the European Anti-Torture Committee, clearly demonstrated a disturbing track record of systematic torture in Turkey, but Turkish state authorities, without any exception, labeled them as part of a misinformation campaign against the country and against the AKP government, instead of adequately investigating them. And perhaps more strikingly, a number of high-ranking government officials in TV interviews and in many non-official occasions, gatherings, have clearly encouraged the use of torture, for people who are allegedly affiliated with the Gülen movement. And in one instance in 2017, for example, President Erdogan himself stated, and I quote, "We are purging every Gülenist in our state institutions. We will eradicate this cancer from the body of this country and the state. They will not enjoy the right to life. Our fight against them will continue until the end, and we won't leave them wounded." And such cruel political rhetoric clearly contributes to the climate of impunity in the country. And the fourth issue is ineffective and delayed investigations by prosecutors. Now, in the report, we compiled the official judicial statistics between 2013 and 2018 on Articles 94 and 95 of the Turkish Criminal Code. And these two provisions in the Turkish Criminal Code punish the use of torture by police by imprisonment from 3 to 12 years. And we see that each year there have been over 1,000 criminal complaints, and over 90%, I mean, roughly 900 of them are not investigated at all. And out of the 10% that reaches the trial stage, only a handful of imprisonment decisions is issued, and the ratio stands around 1%. So there is clear unwillingness on the part of Turkish prosecutors to investigate these serious claims of torture and eventually hold perpetrators to account. And maybe one example that we zoom in on in the report is the commencing and serious allegations of torture and sexual abuse of several detainees in Turkey's Urfa province. In May 2019, due to a clash between the PKK and the Turkish police, one police officer lost his life, and the Urfa Public Prosecutor Office launched an investigation into this incident, and over 50 people, mostly Kurdish people, were taken into custody. And during the custody, many of them indeed reported that they had been subjected to torture and ill treatment, including rear handcuffing, blindfolding, hooding, electric shocks, beatings, sexual abuse, as well as verbal abuse or threats. I mean, this of course caused a public outcry, and a number of human rights organizations in Turkey, including the highly regarded Human Rights Foundation, provided conclusive evidence in their report, but the prosecutor office simply issued a public statement and denied all allegations. And the final factor ensuring the impunity—
You have 2 minutes. 2 minutes.
Okay. And the final factor ensuring this pervasive impunity policy is, to say the least, the complicit judiciary in Turkey. And over the past decade, we see that Turkish judiciary has been experiencing some severe challenges, such as political pressure, the arbitrary dismissals, and widespread censorship among judges and prosecutors. And this has largely resulted in the politicization of the judicial branch in Turkey. And now the judiciary should act as a remedy against human rights abuses, but unfortunately, the opposite is happening in Turkey. Judiciary is itself responsible for a whole series of human rights abuses, and this is indeed visible in many court decisions, especially in cases of enforced disappearances and extrajudicial killings of Kurdish people. from the last decade. And we provide a long list of cases in our report, so I would encourage you to check the report. And to conclude, the findings of our report clearly show the organized, institutionalized, and entrenched impunity problem in Turkey. And we regrettably had to note that the practice of impunity has virtually become the norm for human rights violations committed by state officials. And we hope that Turkish state authorities soon start taking some structural steps to fight the root causes of the impunity before it's too late. And I'll stop here. Thank you.
Thank you very much, Emre. I think it's a clear introduction to the team. Once again, welcome to a lot of people have joined us meanwhile. Okay, now I would like to give the floor to someone who has been studying this problem of impunity on a larger territory, let's say. Mrs. Orsola Casagrande, she's a journalist and co-author of Fight Impunity Report, and she will explain the findings of the report, of course, and also talk about impunity, but more worldwide and compared to what's happening in Turkey. I would like to thank Mrs. Casagrande to be with us, and I'd like to give you the floor for a good 10 minutes, something like that. Thank you very much to be with us.
Good afternoon, everyone. Herkese merhaba. Thank you for the invitation and the opportunity to talk about this new initiative promoted by the Association Against Impunity and for Transitional Justice and by the Italian Società Informazione. The 18th report on rights, the state of impunity in the world, as the title clearly indicates, offers a detailed overview of the state of the art in the field of impunity. And this year, the volume comes out in English as well as in Italian. The work we carried out aimed at broadening the discourse and addressing impunity by analyzing not only war and humanitarian crimes, genocides and systematic violations, but also environmental, economic, and social crimes. Of course, the coronavirus pandemic has been somehow the perfect alibi for many governments, but also, as it is the case in Turkey, Kurdistan, and Colombia on the other side of the ocean, for many parastate groups. In fact, the coronavirus has given many governments the opportunity to continue with the erosion of rights won through struggles and sufferings for years, while at the same time giving to parastate groups the green light to continue to commit slaughters covered by a disturbing silence of the media interested in the virus rather than in what is going on around us. And I just like to mention here, so to in a way to enter of impunity, I just want to mention the Moroccan occupied territory of West Sahara and the repression of the Sahrawi people, which is hardly covered by the mainstream press and therefore goes on with impunity. And we can only mention here, because of time, a few cases, but the report a very in-depth overview of many Latin American countries. If we were to make a parallel with Turkey, of course, always keeping in mind every territory has its specific characteristic and issues, whether for good or bad, we see that repression is in Turkey, like in other countries, the democratic and legally and freely elected opposition, but also activists, human rights activists, trade unionists, students, as it is the case these days with the university protest, and of course the press. And being a journalist myself, I failed to mention that there are over 100 journalists in prison in Turkey and hundreds more under investigation, as well as there are hundreds around the world. And of course, we have to add the fact that often impunity prevails because because of the silence of the international community. International community, which often close an eye or even it comes to crime, whether being crimes against humanity or crimes against nature. And this, the weak reaction of the international community, I think is one of the big problems, one of the big issues that need to be addressed. And at these days, I want to underline that mark the third anniversary of the Turkish invasion of Afrin, and I think sadly this is the case in point as to the silence and thus somehow to the complicity of the international community. We know that Afrin not only was invaded by Turkey and its proxy, but we know that 3 years on, we are witnessing some of the most horrific crimes being on in Afrin, and all of this in the silence of the international community. And so for us, the report, and I want to go back to Colombia just to close. The Colombia, and I like to make this parallel between Turkey and Colombia because Turkey came off of an attempted peace process, so to say, and then the coup, and then now a situation in which human rights are really walk over. In Colombia, the process was successful. And in 2016, as you all know, the Colombian government and the FARC-EP signed a final peace agreement in Havana. But unfortunately, 3 years on, the situation in Colombia in terms of violation of human rights and therefore impunity, because unfortunately the two go together, it is horrendous. And as I mentioned before, only the 21st day of 2021, we have already seen and witnessed the killing 12 social leaders and human rights defenders, and to which we have to add 4 former FARC combatants. So the states of the aftermath of the peace process is actually sadly very negative. And as I said before, the silence of the international community unfortunately contributes to impunity and to the prevailing of impunity. So for us, one of the main point in this report was that identifying first of all, and then contrasting with information, awareness, political and legal action, accountability of sovereign bodies and the decisions at the global level means talking about global rights and interdependence between rights, as well as using this as a way to fight impunity. There is not much time to go in depth into the different cases. But what I like to say to close up this first intervention is that yes, unfortunately, impunity is the common denominator in many countries around the world, and also, as I was telling at the beginning, unfortunately, the coronavirus pandemic has helped impunity to walk free and to walk without being persecuted. Thank you very much.
Thank you very much for this concise explanation. Thank you very much. For the audience, some people had some problems with the interpretation that they didn't ask for, but if you have a problem, you just put on interpretation and make again the choice for English or Korean, and probably that will work. But anyhow, that was a very good presentation. I think that Orsola has been presenting a report to the European Parliament that has been presented, and so we have the honor now that Mrs. Maria Arena is also here. She's the president of the Subcommittee on Human Rights of the European Parliament. And I don't know if Maria could see, but there are two questions also a bit in the same context that I would like her to ask now or later. That is how the European Parliament reacts on the Magnitsky Act. But perhaps it's good that when later on we have Michael Polak talking about that, and I give afterwards the floor to Maria to answer, to give her view on the application of the Magnitsky Act at European level. Okay, so but Maria, can you start now and say a bit how the European Parliament looks at this problem?
Thank you, Johan, and thank you for inviting me. It's a pleasure to meet you in this meeting. And of course, I will react on this sanction mechanism proposed by Mr. Borrell to the Council and how the Parliament is working on it. But first, I wanted to say that at the Human Rights Committee, subcommittee at the European Parliament, we work a lot against and fighting against impunity. It's one of the top of our priority, because we know that there is no democracy without justice. There is no peace without justice. It is the name of the NGO. And it's important because when there is no justice, people are paying two times. They are paying because they are victims, and they are paying because there is no remedy for them. So it is really something that give out the trust on the system when there is no justice. And so it is why at the subcommittee, we wanted to make it a very big priority. We work on three different pillars that are really important for the European Union. The first one is how to deal with impunity at the multilateral level. And as you know, multilateralism is really under threat for the moment. Sometimes we are seen as the only one to defend human rights, rule of law at the international level. We hope that with the Biden administration, we will have new alliance with United States on this, because with Trump, it was really difficult to work with when it comes to impunity. For example, Trump attacked directly the prosecutor of the International Court, Criminal Court, saying that they wanted to ban them from the United States territory just because they work on the Afghanistan situation. And so it was really a threat for multilateralism and ICC. So the first priority for us in the Human Rights Subcommittee is to come back to this multilateralism, to support ICC and to promote ICC all over the world and to find alliance with that. We also have seen that despite the attack on the International Criminal Court, the fight against impunity is also being waged on new ways, such as through development in universal jurisdiction, whereby, for example, crimes committed in Syria are being investigated and punished under German or Danish law. And this is really important. It is an important development in this respect, is that not only crimes, for instance, committed by Islamic State are regarded under a counter-terrorism perspective. This is a new way to look at how to pursue the quest for justice for international crimes. And so we also have to work on these new initiatives that we can have in different member states. The second point is about considering multiplicity of investigative mechanisms worldwide with international crimes. Impunity doesn't start with legal proceeding. It begins immediately after the crime, and we need to have the different proof of these crimes, to organize the different proof of these crimes. It should be noted that there are currently many mechanisms to fight against impunity. Often these are investigative mechanisms, and that there is no necessarily articulation between them. Of course, they are the result of negotiation in different challenging contexts. I talk about Syria situation. It is not so easy to coordinate all these mechanisms, but it is necessary to have this kind of coordination when it comes to this proof that we have to have in this country. The third one is the point regarding the broad concept of the fight against impunity. The fight against impunity concerns, of course, crimes committed in situations of armed conflict, violation by parties to the conflict against civilians. We always forget this desperate case, for example, of Yemen, where the international community, and Ursula told the same story, is still stuck on making the party to the conflict accountable for international humanitarian law violation. In other accounts, for example, Belarus, we have worked a lot of Belarus at the European Parliament, whose government must be made accountable for violations against opponents, is a challenging example, as the country is not a party of the Rome Statute, which makes the reflection on impunity more complex on this situation in Belarus. However, giving visibility to those collecting evidence on human abuses in the country through Parliament Sakharov Prize, for example, is also something that we are dealing with at the European Parliament. And we have, for example, at the European Parliament, with the Council and the Commission, we have this instrument, is the Endowment for Democracy instrument, is just helping civil society in a country without institutional decision in this country, and to give the opportunity to this civil society to survive to the regime, because it is, and we have this in Turkey, it is very, very difficult for civil society to survive to the authoritarian regime. So we need to have some instruments coming from the European institution, but not politically identified as European institution to support this civil society. So for us, it's really important to work on this. I will mention also a work that we are doing for the moment at the Human Rights Subcommittee is on the responsibility of companies, because we are also always speaking about the government responsibility, and it is really important to tackle this responsibility, the accountability for government. But we also have to work on the accountability for companies, because in some cases, companies are allied from the authoritarian governments. And we have, for example, in Turkey, but not only in Turkey, in Belarus or other countries, companies being really next to the regime, benefiting to the regime and paying the regime to continue to live. And so it is important for us to have mechanisms at the European level to make these companies accountable, and not being able for European companies to work in this country, but also to have these national company to be present in the European level. And we are working on this due diligence mechanism at the European level, just to make these international companies being responsible from their human rights violation in some countries. And this is really important, because human rights, it's not only a question of public human rights, it is also important to give this responsibility to company. And I take the example of Chinese Uyghur people. We have a lot of Western companies being in China, using this forced labor and coming back to Europe, selling these products. Are we ready to accept that? Or can we force this company not to be complicit of the Chinese regime? And this is what we are trying to do for the moment. And the last, and it is to answer to the global sanction mechanism, it is also to have this sanction mechanism more flexible at the European level, to guarantee that people being being responsible for violation of human rights, not giving them the opportunity to have assets in Europe and to have visa in Europe. And this is the proposal from Borrell on the sanction-based mechanism. I don't want this sanction-based mechanism called the Magnitsky Act, because Magnitsky, it's another story. I want to have this European mechanism, and not to say that we are just following American on this, United States. So it's really essential to have our own mechanism on this. When it comes to Turkey, as you know, we have had this discussion today at the plenary session when it comes to our Demirtas colleagues being in jail since 2016. It is not the first time that we have had this discussion at the European Parliament when it comes to Turkey. We have had a lot of resolution against this regime in Turkey, but I must say without big effects on this. Even if some decisions have been made by the European level, for example, the accession process is suspended for the moment. The funds disbursed for this process are totally blocked for the moment. Negotiation for the modernization of the custom union is totally blocked also, and also the visa liberalization are frozen. So it's not to say that Europe is not doing anything, nothing on the Turkey situation, but it is difficult sometimes to have unity at the Council when it comes to Turkey. And you know that there are two important things when it comes to Turkey. The first one is the migration issue. And I'm totally against the fact that we externalize our migration policy to foreign countries. And the example of Turkey is a very good example to show that when we externalize our migration issue, that is a very sensitive issue in Europe, we are linked to the power of these foreign countries. And if the foreign countries is a dictatorship, the situation that we have in Turkey, we lose our capacity to complain because, and Erdogan used this, saying that if you complain on the Turkey situation, we will let the migrant enter in the European territory. And so it is not at all a solution to give the opportunity to a country, being Turkey or Libya or Tunisia, the opportunity to take the power of the migration and of the political issue at the European level. This is the first thing. The second thing is also that we have geostrategical relationship with Turkey in Syria, but also in the Mediterranean area. And the only way to change the Council position against Turkey was not about the human rights, not at all. It was only about the energy, about the fact that Turkey is willing to go in the Mediterranean Sea and to make exploratory action on the gas and oil. And for this reason, the Council decided to push sanction to the Turkish regime. So some people said, oh, at least they decided to have sanction to the Turkish regime. But we have to be clear on this. It was not about human rights, not at all. And so what I wanted to do and what I meant to do at the European Subcommittee of Human Rights, it is to push the human rights at the core of our foreign policy. It must be one of our priority when it comes to the relationship that we have with other countries. So we will continue at the Subcommittee of Human Rights to tackle the different issue of the human rights in Turkey. Of course, we will continue to support the civil society. We will continue to denounce it. But what I think it's really important is to ask our member states, Belgium, France, Germany, is to put the human rights at the core priority of the relationship that we have with other countries. Thank you.
Thank you. That was a clear message. And I think indeed, when we see the reaction on the economic difficulties between Turkey and Cyprus on the one hand and human rights, there is a big unbalance. I will use the occasion to ask one or two questions here or there. First of all, to Emre. There was a question that has been asked that says we did not see in Turkey a real movement of victims, exception made the mothers on Saturday. Is there now coming a bigger movement, or are people too afraid to create a movement? Can you just reply shortly on that, please?
Well, to answer briefly, I think, Turkish people are getting more organized, and they're also, victims are also using some strategic mechanisms to challenge all these arbitrary actions by the, Turkish government. But I would definitely encourage them to be, more organized, more structural, more strategic, and make their voices heard, on an international arena.
Thank you. I hope we had a question for Mrs. Arena, but she already answered before the question was put. That was, what is the impact of political and economical interests on not reacting on human rights? So that's very clear. I think it's clear that Europe did not react in the way it should have been reacting towards Turkey, candidate member state still, anyhow. Because of the whole economic and specifically the migration situation. They gave out the power on human rights out of hands, I think, and Maria was answering that. Some people ask, how is it still possible that all this happens, torture, all these violations, and why are not more reactions? But I think I have to emphasize also, and that we see in all the different reports, a lot of people who could react are afraid. And they have reason to be afraid because the repression of it is very huge. We will have very soon now Mrs. Avazyan, and she is a living example of how people who speak up in Turkey are prosecuted and getting victim of these violations. So why it can happen? Because the sanction mechanism in these doesn't work. And we have a national sanction system. It's clear from what Emre told and explained, it doesn't work. So we should have the international one. And we have an international one, the jurisdiction, the International Criminal Court, but unfortunately, until now, Turkey didn't accept it. It's not a member of it. And one of the first things to do is that this international criminal court has to get more power. And that's a long shot still. I also can announce that with the Turkey Tribunal, we are looking at the possibility to enter a complaint it's a very long shot, it's difficult, but we will try anyhow to go to the International Criminal Court. Now we have something I'm always a bit afraid of. We have a video, and it's an important one because we are talking now about principles and so, but the video we have is from someone who was living it actually. Yeah? And so we can easily talk, but that's a video from Erkan Turkut. He is the brother of Kemal Turkut, and he was a Kurdish young person shot dead, clearly with video footage. There is no discussion by the police in a celebration, level celebration, which is a traditional festivity in the Kurdish territories. And afterwards, after 5 years of, how to say, fake prosecution, if I may say so, the policeman has been acquitted recently. And now we have this statement, this testimony of the brother of Erkan.
İsmim Ercan Turkut. Kardeşim Kemal Turkut 2017 Nevruz'unda Ahmet'te alana girmeye çalışırken polisler tarafından öldürüldü. Polisler ilk etapta çevrede bulunan gazetecilerin ve kameramanların görüntülerine el koydu ve o esnada bulunan delilleri karartmaya çalıştı. Sonrasında Diyarbakır Valiliği alana girmek isteyen bir canlı bombanın etkisiz hale getirildiği haberini kamuoyuna duyurdu. Sonrasında kardeşimin cenazesi Malatya'ya geldi ve Malatya Valiliği devreye girdi. Malatya Valiliği cenazenin morgda yıkandığı esnada suyu kesti. Tabut talebimizi reddetti. Taziye çadırı talebimizi reddetti. Babamızın yanına gömme isteğimiz sit alanı bahanesiyle reddedildi. Sonrasında akşam saatlerinde bu olayı öngörebilen bir gazeteci arkadaşımız elindeki fotoğrafları basına verdi ve olayın bir canlı bomba vakası değil, bir infaz olduğu ortaya çıktı. Sonrasında 2 polis gözaltına alındı. Biri aynı gün, diğeri de diğer gün serbest bırakıldı. Yaklaşık 1 yıl sonra savcılık kasten adam öldürmek suçlamasıyla Diyarbakır 7. Ağır Ceza Mahkemesi'nde dava açtı. Ve bu dava yaklaşık 3 yıl sürdü. Davada gelen tek rapor vardı. İlk gelen rapor savcının iddianamesini doğrular nitelikteydi. Fakat katil ve avukatı bu rapora itiraz ettiler. Ve mahkeme bu raporun tekrar gelmesini istedi. Gelen raporda da katilin ifadelerine uygun bir şekilde hazırlanmış bir rapordu. Bizim avukatlarımızın hiçbir talebi kabul edilmedi. Katil bir gün bile tutuklanmadı. Ve devam eden mahkeme sürecinde katil delil yetersizliğinden beraat etti. Bu olayda ne görüntülere el koyan polisler, ne yalan söyleyen valilik, ne Malatya Valiliği hakkında herhangi bir soruşturma açılmadı. Mahkemeler esnasında bir mahkemede mahkeme heyeti ve katil aynı kapıdan annemin yüzüne sırıtarak içeri girdiler. Annemi birkaç defa mahkemeden dışarı attılar. Bu süre içerisinde devletin herhangi bir yetkilisi ayrı olarak bizim yanımıza gelip başsağlığında bulunmadılar. Ve dava cezasızlıkla sonuçlandı. Biz bu davanın takipçisi olacağız. Bu dava burada bitmedi. Bu davayı sonuna kadar götüreceğiz. Çünkü cezasızlıkla sonuçlanan bütün mahkemeler yeni cinayetlere gebedir. Biz artık yeni cinayetlerin işlenmesini istemiyoruz ve adalet istiyoruz.
Thank you very much. I think very chilling testimony that we have. We can discuss, but of course this is a tragedy, and it is only one of the example that also was taken into account for the report of Emre. We have now for a second person who is directly actually from Turkey intervening, and that is Mrs. Natali Avazyan. She is a human rights activist actually, and she has been herself all the time active, and by that only by being as an activist been victim of prosecution several times. But she's most of all standing up for abuses towards women and children specifically. And I'm very thankful that you're here, Natali. It's not so easy to do that. And we are grateful, and I would like to give you the floor. Thank you very much.
Merhaba, sizlerle burada olmak çok güzel, mutluluk verici.
Yes.
Tüm katılımcılara sevgimi iletiyorum. Evet, Türkiye çok zor dönemlerden geçiyoruz. Eğer hükümete karşıysanız terörist oluyorsunuz. Hakkınızda soruşturmalar açılıyor. Davalar açılıyor. Nasıl anlatsam? Son aylarda işkenceden bahsetti arkadaşlar. Evet, kadınlar çıplak aranıyor. Biz buna dile getirince şey oluyorsunuz, terörist oluyorsunuz. Tırnak içinde FETÖ'cü oluyorsunuz. Evet, ben çocuklara ve kadınları savunuyorum. Din, dil, ırk ayırt etmeden. Onların siyasi görüşü beni ilgilendirmiyor. Onların inancı beni ilgilendirmiyor. Ben mağdur olan kadın ve çocuklar için sesimi yükseltiyorum. Tabii bu da hükümetin hoşuna gitmiyor. İşte çok sık evime polisler basıyor. Gözaltına alınıyorum. Hakkında tahmin edemeyeceğiniz kadar çok davalar var. Benim en büyük endişelerimden biri 15 Temmuz'dan sonra ben sesimi yükseltmeye başladım. Çünkü çok büyük haksızlıklar oluyordu. Kadınlara, çocuklara çok büyük haksızlıklar oluyordu. Hiçbir kadın dernekleri cemaat üyesi olan kadınlara savunmuyordu. Benim bunu aklım almıyor. Sadece cemaat üyesi kadınları savunmuyorlar. Herkes kendi mahallesine demokrat oluyor. Ben bunu dile getirince tabii ki çok suçlamalar üzerime atıldı. Ama ben hepsine kulağımı tıkadım ve sesimi yükselttim. Kadınları ve çocukları savundum. Benim en büyük endişelerimden biri, bakın anneler doğum yapıyor, doğumhanenin önünde polisler bekliyor. Kadın doğum yaptıktan sonra alıp hapishaneye götürüyorlar. Çocuklara gelince erkek çocukları için çok endişeleniyorum. Düşünsenize 1 yaşında bir çocuk 5 yıldır annesiyle beraber hep kadınların içinde. İleriki yaşlarda bunların kimlik arayışı beni çok böyle o kimlik arayışında çok büyük zorluklar yaşayacaklar ve bu çok üzücü. Ben bunu sürekli dile getirdim ama tabii suçlanıyorsunuz. Evet, Türkiye'de işkence var. Türkiye'de işkence var. Ben tabii resmi olarak ben size rapor sunamıyorum. Fakat ben bu olayları yaşayan kadınlarla, erkeklerle, avukatlarla görüştüğüm zaman bakın hapishanede olan çocuklara yiyecek verilmiyor. Anneler kendilerine verilen yemeklerini çocuklarıyla paylaşmak zorunda kalıyor. Bu bir işkencedir. İşkence sadece size elektrik verilmesi, işte joplanmanız veya işte dövülmeniz değil ki. Hapishanedesiniz ve çocuğunuza yemek verilmiyor. Bu çok büyük işkencedir. Çıplak aranıyorsunuz. Ben bakın sadece şunu söyleyeyim. Hükümet yanlısı bir gazeteciyi Twitter hesabından sadece bir yorum yaptığım için 18 tane polis sayabildim. Evimi bastılar. Annemi ziyarete gitmiştim. 18 tane polisi sayabildim. Alıp götürdüler. Gözü altında çıplak aramaya maruz kalındım. Sadece hükümet yanlısı bir gazeteciye yorum yaptığım için. Size hakaret ediliyor, dava açamıyorsunuz. Size hakaret ediliyor, soruşturma açılmıyor. Yok sayılıyorsunuz. Gerektiği kadar konuşamıyorsunuz, Örneğin ben CHP'yi destekliyorum ve orada Kemal Kılıçdaroğlu'na yapılan hakaretleri ben savunamıyorum. Ve hakkında tekrar bir dava açılmasından korkuyorum. Bakın şurada komşunuz, biliyorsunuz ki komşunuz aç ve götürüp yemek veremiyor insanlar korkudan. Yardım edemiyor. Çünkü siz o zaman terörist oluyorsunuz. Teröristi savunuyor oluyorsunuz. Teröriste yardım etmiş oluyorsunuz. Bir sabah uyandığınızda terörist olarak uyanabiliyorsunuz Türkiye'de. Geçen hafta Cuma günü polisler aradı. Yine hakkında dava açılmış. Avukatımla birlikte biz gittik. Bakın yemin ederim ki bir dosya hazırlanmış. Terör örgütü propagandası yapıyor diyor benim için. Dosyayı açtığımızda benimle ilgili hiçbir şey yok. Ben RT yapmamışım, favlamamışım, yorum yapmamışım ama hakkımda terörist propagandası yapıyor diye dava açılıyor. İnsanları açlığa mahkum ediyorlar. Kadınlara çalışma izni verilmiyor. KHK ile atılan kadınlara, erkekleri çalışma izni verilmiyor. Kadınlar birbirine yardımcı olduğu için onlar terörist ilan ediliyor. Gözaltına alınıyor. Avrupa Birliği bunlara nasıl böyle sessiz kalabiliyor? Benim bunu aklım almıyor. Sesinizi yükseltmiyorsunuz. Kusura bakmayın. Bu çok üzücü. Evet, sorunuz varsa alabilir miyim? Çok böyle gerildim. Avrupa sessiz kalıyor. Avrupa sessiz kalıyor. Çocuklar ölüyor. Bakın Meriç'te geçerken buradan aileler kaçmak zorunda kalıyor. Meriç'ten geçerken çocuklarını kaybediyorlar. Anneler, çocuklar kanser oluyor. Anneler tedaviye götüremiyor. Neden siz bunlara sessiz kalıyorsunuz? Ben biyolojik olarak anne değilim. Bu süreçte benim üzerimde evlat sahibi oldu. Bu benim için çok büyük mutluluk. Onların yanında olmak, onların derdini dinlemek, onlara yardımcı olmaya çalışmak, onlara annelik yapmak bana mutluluk veriyor. Lütfen yalvarıyorum size ya, yalvarıyorum size. Çocuklara ve kadınlara sahip çıkın. 1 yaşında annesiyle hapse giden bir erkek çocuk 5-6 yaşında hapisten çıktığı zaman o kimliğini arayacak. Ne yapabileceğiz biz? Çünkü sürekli kadınlarla birlikte olan bir erkek çocuğu ileriki yaşlarda onun yaşayacağı psikolojik sorunları düşünebiliyor musunuz? O nasıl bir kimlik arayışına girecek? ...40 tane genç üniversite öğrencisi, cemaat üyesi 40 genç kızı çıplak aranmayla ilgili HDP milletvekilimiz Gergerlioğlu'na mektup yazarak bunu bildirdiler. Ve Türkiye'de tantana koptu. Böyle bir şey yok diyor. Hayır, Türkiye'de çıplak arama var. Ben 12 Şubat 2020 yılında gözaltına alındım ve 13 Şubat 2020 yılında bir video paylaştım. Çıplak aranma yapıldı ve nasıl yapıldığını ben videomda anlattım. Ama hükümet ısrarla böyle bir şey yok diyor. Sadece hükümeti karalama olarak görüyorlar. Yapılan işkenceleri anlatmak. Evet, Türkiye'de işkence var. Çocuklara da işkence yapılıyor, kadınlara da işkence yapılıyor, erkeklere de işkence yapılıyor. Lütfen artık görmezden gelmeyin. Yaşananları kulaklarınızı tıkamayın ve görmezden gelmeyin artık. Biz hakkımızı sosyal medyada arıyoruz. Twitter'dan arıyoruz. Çocuklar babalarını Twitter'dan arıyor. Kayıp insanlar kaçırılıyor. Eşler, kadınlar eşlerini Twitter'dan arıyor. Sağlığımızı biz Twitter'dan arıyoruz, adaleti, hukuku, her şeyi biz artık sosyal medyadan arıyoruz. Avrupa gözünü kapatıyor, kulağını kapatıyor. Avrupa bunları görmüyor. Hani insan haklarıydı? Söyleyeceklerim bu kadar.
Thank you very much, Natali, for this touching witness testimony. It's not easy, of course, and we clearly see how important this issue is. And we try to support as much. I think your testimony has been a cry out, not to silence. Just to speak up. Everyone has to speak up, and I think that's the most important. We also know that whatever we do, we cannot change situations fast, but everyone should really speak up, and that's the clear demand you gave, and that's the demand we will respond to. And thank you very much once again for being here. I also want to say to all the people who are attending, we have 2,200 people who are attending this webinar, so your thing will be heard. Also, Natali, it will be heard because we're more than 2,000 people. And we have a lot of questions, and we try to answer as much as possible, but that's unfortunately not so easy. Anyhow, I go to the last speaker already of today, and that's Michael Polak. That is this legislation. It is known indeed, but Maria Rina doesn't like the name, as the Magnitsky Act. Traditionally, human rights sanctions are from country to country, and they are not focused on who are the perpetrators. What is happening now, the different countries and also the European Union has taken an initiative, so not only the country as such, but also the perpetrators can be sanctioned by other countries. So, and Michael Polak is busy with an initiative on that, so I will try to give him the floor, and Michael, to explain the action you're busy with on this, what we call Magnitsky Act, but the Human Sanctions Human Sanctions Act, something like that, is the real name. Michael, you have the floor.
Johan, thank you very much, and thank you to everything the Turkey Tribunal is doing, raising the very important question about what's happening in Turkey at the moment, and raising those voices up where they need to be heard. I'm going to speak to you briefly. My talk will cover the law, and sometimes that can be a bit more difficult to listen to than direct accounts of what's going on. But I will try to keep your interest if I can. I'm a barrister at Church Court Chambers in London. I'm practicing criminal and international law. I'm the director of Justice Abroad. Justice Abroad takes on human rights cases around the world. And we also look after mostly British people who get in trouble overseas. I'm the chair of Lawyers for Uyghur Rights. If anyone's interested in that, they can have a look at lawyersforuyghurrights.com. And we work at strategies in regards to the Uyghur people who are being violently repressed in China at the moment. My specific interest in regards to the law is what this conference is all about, looking at impunity of individuals. And I look across the board, different areas of law. So not just focusing on criminal law, also looking at civil suits, sanctions, the UN system, even private prosecutions. And there is every day a wider and wider armory for those looking to combat human rights abuses, and more bits of legislation, bits of law we can use. Those who are watching will know that lots of cases have been brought for crimes against humanity across Europe in places like Sweden and Germany. So there are more options which are becoming available. And the sanctions regimes, which are very new in my country, in the United Kingdom, is another weapon that we can use to combat impunity. And that's why I find it very interesting. In the matter that I'm working alongside a Queen's Counsel, which is a senior barrister called Kevin Dent. And we're instructed by the Arrested Lawyers Initiative. The Arrested Lawyers Initiative is a fantastic voluntary group of Turkish lawyers who are working against the attacks on the rule of law and the attacks on lawyers themselves in Turkey, which have been terrible. The problems for lawyers in Turkey are huge. Many people watching will know about them. Thousands of lawyers have been arrested, tortured, and some have even died within custody. Now, lawyers in Turkey seem to be treated as if they hold the same beliefs or the same political beliefs or other beliefs as their clients, whereas we all know that that's not how lawyers work. They don't adopt the beliefs of their clients, but they simply represent them to the best of their ability. So often in Turkey, lawyers are being punished for the actions of their clients or the beliefs of their clients, which is very worrying and makes it a very difficult place to be a lawyer. So what's going on in regards to lawyers? There's been a relentless campaign since 2016. There's been arrests of lawyers across all of the provinces in Turkey. And these have reached all kinds of levels, presidents of bar associations, even judges who refuse to act on the government orders have been arrested. You've had high-profile civil society activists, as you all know. You've had the head of, or the director of Amnesty International in Turkey. So it really has touched all areas of the law, and no one has been spared. In heartbreaking recent news, the world learned about the death of Ebru Timtik, who passed away on hunger strike, fighting simply because she wanted a fair trial. Now, what's this project? What's it about? Arrested Lawyers, they launched this project. They call it the Turkey Human Rights Accountability Project. You can have a look at arrestedlawyers.org if you want to have a look for it. There's a page on their website. And this was in response to these continuous breaches of the rule of law and imprisonment of lawyers. What we're seeking to do, and this is the first step of their campaign, to target impunity, mostly for actions against lawyers, but we're also considering other actions against civil society activists and other people as well. So we're not just limiting it to the repression of lawyers, but that's the focus of it. We're seeking to utilize the United Kingdom's new global human rights sanctions regulations to challenge those involved in political prosecutions, in keeping people in prison, in the torture of people when they are in Turkish police custody or in prison as well. Now, it's a very exciting time for us in the United Kingdom in regards to sanctions, because for the first time in the last 50 years or so, we're doing our own sanctions in the United Kingdom. Before, all of the sanctions used to come through the European Commission, and the UK would just pass enabling acts to enforce those sanctions. So we didn't have much of a role in actually deciding. Well, of course, at the European level, we could decide who was subject to European sanctions, but we didn't have much of a role in deciding what type of people should be subject to sanctions in a UK context. Now the UK has to do all its own sanctioning. So they've scrambled to put together legislation so that they can target the people they think should be sanctioned. There was an act put in place in 2018. It's the Sanctions and Money Laundering Act. We call it SAMLA. We've given it a short name. And what that did is it provides the legislative background for the government to apply these new sanctions. And sanctions come, of course, from the United Nations Security Council. And at the European level, these are applied through European Commission, and then all European Union states have to enforce those sanctions. But now the ministers, UK ministers, will have to enforce sanctions, and they can do so on three main bases: for the purpose of compliance with the United Nations obligations. So any UN sanctions will be applied by the minister in the United Kingdom. For the purpose of compliance with any other international obligations. So if there's any other international obligation in the UK to apply a sanction. And then for these other purposes. And it's these other purposes which I think are the most interesting part to look at. And there's a whole list of them. I'm not going to read out all the list of why a minister can put sanctions in place. Some of the things on there are things you'd expect: the prevention of terrorism, interests of national security, that kind of thing. But there's more interesting areas there as well, furthering the foreign policy objective of the United Kingdom. And the main one that we're looking at today is to provide accountability or be a deterrent to gross violations of human rights or otherwise promote compliance with international human rights law or respect for human rights. So it really empowered the minister to put in place these sanction regimes to combat those kind of human rights abuses. There is a power to challenge a designation under the sanction regime, but I'm not going to go into that today. If anyone's interested in that, I'm happy for them to ask me about it. Now, what happened? So SAMLA was passed, the overarching act, and a regulation was made by the Foreign Secretary. And this is the Global Human Rights Sanction Regulation 2020. So it's very new. We don't have any case law under it in regards to giving us under what circumstances you can challenge it, or under what circumstances, which I think is more interesting, you could challenge the government or the foreign minister not actually adding someone to the list. So it's a very new area of law for us and very exciting area as well. So it's our foreign minister who has the power to sanction. And of course, he takes advice from the government in doing so. But it's not an open power. The Global Human Rights Sanctions Regulation set out certain things he has to take into account. He has to have reasonable grounds to suspect the person is an involved person. On an involved person, I'll come to what we're looking at with involved persons, because that's quite relevant for the Turkey scenario, who may be caught up in these sanction regimes. And also he needs to look at the significant effects of the designation on the person. So it's not necessarily that the foreign minister will sanction everybody in a certain regime. And if you look online, you can see the sanctions which have been made so far. We have the president of Belarus is on there. A number of Saudi politicians are on the list. Lots of the Russians who are involved in the poisoning in Salisbury are on the list as well. So you can have a look at the type of people who have been added so far. There are, of course, a number of missing areas of the world and missing people. And that's really what we're working on with this project in regards to Turkey. Involved persons, I said I would come back to that just briefly. It's someone who is involved in an activity, someone who conceals evidence of this type of activity, and someone who is responsible for the investigation or prosecution of an activity, and fails to fulfill that responsibility. There are other involved activities, but you get the point. It's someone who is involved in some way, is supposed to be preventing these human rights abuses. Which human rights abuses are we looking at? Well, the regulation sets out specifically which ones the government should be looking at. They're the right to life, the right not to be subjected to torture or cruel, inhuman, or degrading treatment or punishment, and the right to be free from slavery. So fairly fundamental human rights provisions. So they're the ones we're focusing on with our submissions, because that's what's set out in the regulations. Now, what are the effects of a designation? If we choose someone and add them to the list, what are the effects on them? There are financial effects. It would freeze the assets of a designated subject, and it means that no other person should deal with them with funds or economic resources. If they do so, they're committing a criminal offense and can go to prison for up to 7 years. So it's quite a serious criminal offense if someone did deal with someone on that sanctions list. I'm sure some of you have gone and found the list. It's quite an interesting list to have a look at, those people who have been added so far. Further to that, there's also exclusion of that person for entry purposes into the United Kingdom. So that those people who find themselves on that list cannot travel to the United Kingdom. At first, we thought they wouldn't go for high-level people, but you can see since they added Alexander Lukashenko, president of Belarus, they've really gone to the top of that regime in Belarus, which I think is promising, and I think that's a good thing. There are certain factors that the Foreign Secretary will take into account when deciding who to designate. In regards to legislation, there's a wide range of discretion for the Foreign Secretary to make these decisions, and they're based on Her Majesty's government's human rights priorities. So what they look at is, what are the priorities of the government in regards to human rights? The current priorities are media freedom, combating modern slavery, preventing sexual violence, freedom of religion or belief, torture protection, and most relevant for today's purposes, the protection of human rights defenders. So one of the priorities is to protect people like the brave lawyers in Turkey who are standing up and defending people against the Turkish government in very difficult circumstances. So we say the human rights priorities of the governments at the moment fits really in with what we're doing with our submissions. There's the nature of the victims as well. And once again, it lists human rights defenders and whistleblowers as the kind of victims that the government is focusing on at the moment. The seriousness of the conduct, the international profile of the case, the status and connection of the person. So the government, if they're looking at a whole regime like the Turkish regime, they will look at who's more likely to have an effect if they sanction them. So would it send a message to other people who are doing the same job as those people? They also look at the effectiveness of other measures. And as other speakers have mentioned, there is a very ineffective scheme for challenging human rights abuses in Turkey. So we say it falls under that example as well. In regards to what we're doing, who are we considering? We're considering a large number of people, and we're going to choose a selection of them and make submissions to the Foreign Secretary, written submissions which set out the historical context of what's happening and provide evidence as well. We're looking specifically, one category is Turkish prosecutors. And those who are Turkish here will know the power of a Turkish prosecutor. But for those who aren't, and I was very surprised when I found out about this, because our prosecutors in the United Kingdom get sent their papers, they read them for a few days, and they turn up and prosecute a case. And that's the kind of extent of their involvement in a case. So when it was mentioned to me, oh, we should be looking at the prosecutors in Turkey, I thought, well, that's a bit of a strange idea. But the prosecutors in Turkey have a huge amount of power, and they have a legally mandated obligation to look after victims when they're in custody as well. So if people are being tortured under those prosecutors are, we say, liable. And you'll remember when I went through the legislation, and I know that's a bit of a dry bit, but one of the circumstances where the government can sanction people is those who fail to prosecute people for human rights abuses, for torture, that kind of thing. So a prosecutor in Turkey who's acting for the government could, in theory, fall under two different limbs. the fact they didn't protect someone when they were in custody and they took part in a farce of a court process and someone ended up dead or tortured would be one limb. And then the fact that they didn't investigate that torture properly is another limb. So they'd be liable under two separate limbs at the same time. Who else? Police chiefs operating police stations where people have been tortured and killed. We will be having a look at them as well. Minor politicians as well who've been involved in this mass oppression. So they're the kind of people we're looking at. We're getting our submissions ready. I think sometime in February, we're doing a launch event, and it would be great to see you along for that. We'll be naming the people who we will be asking for sanctions against. We've got lots of strong evidence. If you've got a particular person you think who should be sanctioned, please do get in touch with us through the Arrested Lawyers website. We do want to hear from you. We're doing this on behalf of Turkish lawyers and the Turkish people as well. So if you say, I've got really strong evidence, this person should be on your list, please do write to us. I really encourage you to do that. What's the effect of sanctions? Now, people always go to the effect, and this is my last point really, and they say, well, what's the effect of sanctions? It's not a criminal case. It's not, they won't be punished, won't be put in prison, that kind of thing. But it does send a very strong message to people who are carrying out these kind of acts that the international community do not accept what is going on. And it does have a real practical effect as well. Some of those watching will remember a few weeks ago, the chief executive of Hong Kong, Carrie Lam, who acting under Beijing's instructions, prosecuted lots of brave lawyers in Hong Kong and democracy activists there as well. And she's been complaining about having to carry around bags full of cash with her because of the American sanctions. She can't use any of the banks. And I think that's a really good illustration that these sanctions do actually bite, especially when they're imposed by a broad coalition of countries acting together. And a very interesting point recently, because our United Nations system is failing us because of veto powers of countries such as Russia and countries such as China, there seems to be a trend towards multilateral non-United Nations actions. So when the UK imposed sanctions on the Belarusian regime, this was done at exactly the same time as Canada in an organized, concerted effort. So sanctions in the United Kingdom for certain names in the Turkish regime, prosecutors who are involved in this suppression, could lead to these people not just being listed within the United Kingdom, but being listed across the world as well. And there is a European Union scheme which has just come out, a sanctions regime as well, which is a very good scheme. It's a bit broader than the UK scheme in regards to what they look at. They also look at unlawful detentions and things like that. But we hope if we put together strong submissions in the UK sanctions regime, these can be pushed over into the European Union one as well. Because the wider sanctions are imposed, of course, the more effect they have. So those are my comments. I'm happy to take any questions, and thank you all for inviting me today.
Thank you. I would just give 2 minutes to Maria also, because you had also this European sanction mechanism that Michael mentions. Maria, can you just give us a small comment, because it's just starting up? Give us a small comment on that.
Just a small one. I just like the way you explained this sanction mechanism in UK, and so I think that we have to work together, because it will be very interesting to coordinate also something. I know that UK is outside Europe, so we have to work together on this. And I have a question, and we question also the High Commissioner. It is about corruption. We know that there is a very strong link between businesses, corruption, violation of human rights. For the moment in the European mechanism, the corruption as such is not covered. At least when corruption could be linked to the violation of human rights, it will be possible to have it. What about the UK mechanism? I think it could be very interesting to have this corruption took into account in the mechanism.
Okay, so I think it's important. We were starting with impunity, and we had very strong testimonies, And I think impunity, of course, once again, why things happen because they're not sanctions. It's simple. As long as you have no sanctioning, people go on. It's when you have power to policemen, to politicians, to army, to everyone. We know that already from the 17th century when there is power, power is tended to be abused and you have counterpowers and sanctions needed. Anyhow, as far as the tribunal is concerned, as I already mentioned, we will try, although it's very difficult to go to the criminal court after our tribunal with all the information we have. But with these new systems of human rights sanctions, European level, United Kingdom, Canada, United States, we will try to assemble as much as possible based on all these different reports we have, and most of all of abductions and torture, and send the names, Michael, to you, but we will send them to the Canadian, to the United States, and also the European Union. So to hope that something comes up. We started as a people's tribunal, and I must be honest, at a certain moment, people thought what will come out, but we will not stop with that. The people's tribunal is the start of our action, and we see people joining in, and I would like to thank Natali, Emre, Michael, Orsola, and Maria, because we had a very good conversation today. We had more than 2,500 people who were attending this on an afternoon in the week. It means it is an important subject. We will go on. I want to apologize that I could not answer all the questions. We were a bit overwhelmed. We thought not to have more than 2,000 people attending. That's a luxury problem. Next time we will be a bit faster in answering your questions. Thank you all. Have a good rest of the day. Bye-bye, and thank you very much for attending.